Hello, my name is Michael Robinson. I'm a director at Emerson Solicitors. Just a quick chat about exceptional hardship. I've got a lot of people writing to me saying they're about to lose their licence because they've accumulated 12 penalty points or more. What can they do about it? They then will maybe set out what they consider to be circumstances which would allow a court to not disqualify them from driving. The bar set by case law and the statute is very high. You have to be able to establish exceptional hardship. So not just hardship that's run-of-the-mill, hardship that anyone would expect to suffer as a result of being disqualified. So having to take a bus instead of driving, or having to get your children collected by somebody else to take them to school, rather than you taking them to school, where there's no real perceived benefit to the children in you taking them to school, wouldn't be enough. So what sort of things would qualify? Well, if a grandparent, for instance, or a parent was using a mobility vehicle and you were the designated mobility driver and you were able to drive that vehicle and you were driving that vehicle for them, but the fact that you'd be disqualified would mean that they couldn't get out and about for whatever reason. So they couldn't use public transport. There was nobody else to drive the vehicle. It just wasn't possible. Then that sort of argument would work before a court. If one of your children had, for instance, autism or some other challenge in their life, which meant that you and only you were able to drive them about because otherwise they would react badly to anybody else or to any other situation, so they couldn't get on public transport because they might scream or shout or get terribly upset. Those sort of extreme circumstances, which could be described as exceptional, are the sort of things that you need to be thinking about if you wish to apply to the court. So how do you do it? You simply write to the court or indicate on the forms that you receive from the court that you would wish to argue exceptional hardship. You would explain that in a brief way what you consider to be exceptional hardship. A hearing will be listed, and then you will be able to attend at court, and you will be able to bring with you witnesses who might be able to confirm what you're saying, or you might be able to bring along letters or documents from a doctor or your child's school or from the mobility people, showing that you are in fact in a position which means that should you lose your license, this would adversely affect someone. It can also apply, however, if you are the owner of a business or an employee in a business and you have certain special skills, or you're the person that brings in all the work, and without you there for a 6-month period driving about the country getting in work, the business would suffer. Then you're able to argue that. However, if you have enough money in your business that you're able to afford a chauffeur, then it won't work, because the court will say that you can make other arrangements. So you have to be very careful in how you portray your exceptional hardship to the court. You have to be careful as to the words that you use and how you frame what you're saying. And that's why I would suggest that you really do need legal advice. You can contact me, michael.robinson at emersons-solicitors.co.uk. You can look on our website, www.emersons-solicitors.co.uk, and I'd be only too pleased to offer you some advice and to represent you at court. Thank you.